Good evening, everyone, and welcome to Criminalization of Marital Rape in the Bahamas, a presentation by attorney and CEDAW Committee member Marion Bethel. This is a part of our series that started during the International Women's Day / month recognition in March. And the theme is building the gender machinery. So we recognize that the Bahamas at the moment doesn't have an efficient gender machinery, which should be a central unit at the highest level of government that is focused on gender mainstreaming, working towards gender equality and the advancement of women. So in the absence of a properly resourced gender machinery, we are looking at various tools and resources that are available through international mechanisms and other examples that we see all over the world that we can use to help to move us forward in the absence of that body or that unit. This session today, of course, is looking at marital rape. So we will have a look at the Sexual Offences Act as it already is. We will look at the proposed amendment bill meant to criminalize marital rape. And we will also get a context that's Commonwealth-wide and looking at the region and countries in the region that have been able to make the necessary changes to move those countries forward, and examples that we can look at and maybe pinpoint some things that we shouldn't do and things that we should do. At this point, I am going to hand it over to Marion Bethel, who probably really doesn't need any introduction to anyone here, but Marion, I guess you can give us a brief intro, just for those who for some reason have been under a rock and don't know who you are, and then we can get started.
First of all, yes. All right. Well, thank you very much, Alicia, for inviting me and always welcoming me so warmly to Equality Bahamas' forum. This is not my first time, and I'm really glad to participate in this particular one in celebration of International Women's Day. And yes, in this whole month of March. And so thank you for having me. Yes, as you said, I'm a member of the UN CEDAW Committee. That's what I do from time to time when I leave Nassau to go to Geneva to sit on this particular committee. And other than that, I'm here on the ground doing things that everybody else is doing. All right. So I want to get started. And I think my point is up already. So quite a while ago, I think in 2018, I was commissioned to do by an NGO in London, England, a report on marital rape in the Commonwealth to transforming Commonwealth legal systems. So it was very wide ranging, and several Commonwealth countries we researched several Commonwealth countries, and there is a report on it. And if anybody would like to spend some bedtime reading this report, you're welcome. I have it available. I think Alicia has it too. We can always send it to you. So I'm going to make some extractions from that, but because I'm going to focus largely on the Bahamas in terms of this issue of marital rape, which is really exercising us here in this, in the Bahamas, as it has done and continues to do in many other countries in the world. So thank you very much again, Alicia, for having me. So we're going to look, this is an overview of the presentation that I'll be giving. We'll look at the colonial inheritance. We'll look at the legislation specifically in the Bahamas and see where we are with that and some legislative reforms. Then we'll look at the international and regional human rights instruments that the Bahamas has ratified that speak to this issue of marital rape, and we'll look at a way forward with your input. So the marital rape exception, which is what we have here in the Bahamas, which means that there is immunity for rape within a marriage. And it's only in specific circumstances in the Bahamas, as in other jurisdictions, that you can, that it is an offense. And it's largely through divorce proceedings, judicial proceedings of that kind. We'll look at that a little later. The marital rape exception, it remains lawful in about 22 of the Commonwealth countries, and about 60% of the Commonwealth countries expressly criminalize marital rape. The Bahamas is not one of those. So exemptions for rape in marriage remain common in Commonwealth jurisdictions, despite being contrary to international human rights law. Like many of the flaws in sexual offenses throughout the Commonwealth, marital rape exemptions trace their origin back to British colonial rule. And the exemption or the immunity is attributed to the remarks of a British judge called Sir Matthew Hale. And those of you who've studied law, you will know his name. And it was way back in 1736, about 300 years ago, that he made a pronouncement that became part of the English common law system. And this views women as the contractual property of their husbands, which became part of the common law that Britain exported across the world. This particular common law provision was overturned in 1992 by the House of Lords, but it continues to feature in many Commonwealth countries still. So it's often the case that in England, laws are abolished, but the former colonial territories still carry on with them. So this is Sir Matthew Hale in all his glory. 1736, he says, "But the husband cannot be guilty of a rape committed by himself upon his lawful wife. For by their mutual consent and contract, the wife hath given up herself in this kind unto her husband, which she cannot retract." All right, and this became part of the English common law. So historically then, the English common law had entrenched the concept of women as the property of men and the implied irrevocable consent by the woman to sex upon marriage. So sex upon demand. Rape legislation was originally conceived to protect a man's property from other men, that is, his wife. Through the process of colonization, British colonies inherited the common law system along with the marital rape exemption. So this common law marital rape immunity was further entrenched by William Blackstone, another attorney, and he articulated and reinforced this dictum in the commentaries on the laws of England, 1765 to 69. He says, by marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection, and cover she performs everything, and is therefore called in our law a femme couverte, and is said to be a couvert baron, or under the protection and influence of her husband, her baron or lord, and her condition during her marriage is called her coverture. All right, so sexual provisions, sexual offense provisions in much of the Commonwealth countries still use their original colonial formulations. So if you look at the Indian and the Bangladesh formulations in 1860, you'll see sexual intercourse by a man with his wife not being under 15 years is not rape. So this is 1860. Moving on to 2013, which is fairly recent, the same Indian criminal law had been amended, but it includes all forms of sexual assault involving non-consensual intercourse with a woman. However, the exception, the marital exception, still remains. Sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape, even today. And the same obtains in Bangladesh. The old colonial formulation was used in 1860, and in 2004, the marital immunity still prevails. And so a man cannot rape his wife under those two laws, in those two Commonwealth countries. All right, moving on. So in 1992, this is when the English common law position on marital rape was changed. And so the House of Lords in this particular case, R&R 1992, in the appeal case, confirmed that this common law position had changed. Marriage was to be viewed as a partnership between husband and wife who were equal in the eyes of the law. The court said that it was anachronistic to assume that a woman had irrevocably given her consent to having sexual intercourse with her husband by virtue of being married. Where a statute speaks of the offense of rape, it must be interpreted to include non-consensual sex by a husband with his wife. So this was the case that overturned the common law. And England then codified criminalization of rape within a marriage, I think it was 2003. It's very interesting. I have in the House of Lords, it says here, that a wife giving implied consent to sexual intercourse on marriage was a common law fiction, which had become anachronistic and offensive. It concluded, this is the House of Lords, it concluded that the time has now arrived when the law should declare that a rapist remains a rapist subject to the criminal law, irrespective of his relationship with his victim. I don't think you can get any clearer than that. So that's the English common law, which is now codified. These are Commonwealth countries that criminalized marital rape 1983 to 2000. Canada, New Zealand, Australia, United Kingdom, South Africa, Republic of Cyprus, Namibia. These have all criminalized marital rape. 2001 to 2012, we have another group of Commonwealth countries that criminalized marital rape. And if you go down, you'll see that Guyana in 2010 criminalized marital rape. Grenada, 2012, Trinidad and Tobago, 2012. So I'm just giving you an overview of Commonwealth countries, including Caribbean countries that have done so. Again, 2013 to 2018, you have Tonga, Samoa, and Dominica from the Caribbean, and St. Vincent and the Grenadines. And I don't see our Bahamas there. I'm looking. So the Commonwealth Caribbean states that have removed marital immunity are those 5. So here's Trinidad and Tobago, which has removed it, all right? So Trinidad and Tobago actively participated in the creation of CARICOM model legislation on sexual offenses that provided guidance to CARICOM countries on the removal of language that did not reflect human rights norms and the upholding of women's human rights in particular. So Trinidad and Tobago amended the act in 2012 in terms of the marital rape immunity. And the amendment explicitly criminalized marital rape, whereby the crimes of rape and grievous sexual assault applied to a husband in relation to the commission of the offense on his wife. Guyana is another CARICOM country that has removed the marital immunity under its Sexual Offences Act 2010. And Guyana has, as does Trinidad, a consent-based definition of rape, which is critically important, and it's an international human rights standard that rape should be based on consent, or lack of consent, actually. And Guyana goes on to define consent within sexual violence circumstances. And I think it might be useful to look at that at some point if we have time. And then Guyana goes on to remove the marital exception under section 37(1), which is down below. And it says, unless we're specifically stated in this act, a marital or other relationship, previous or existing, is not a defense to a charge of any offense under this act. And over here, section 3(1) simply lays out the offense of rape, and consent is central, or lack of consent central to that. South Africa also has criminalized marital rape, and this is how they have framed it in their Protection of Family Violence Act under section 5. Notwithstanding anything to the contrary contained in any law or in the common law, a husband may be convicted of the rape of his wife. So I just want you to see that, you know, there are countries that have done it, and I wouldn't say that it was easy. It's been a journey, and it continues to be a journey here in the Bahamas. Rwanda has criminalized marital rape, and it's very interesting language. But Rwanda has based its marital rape criminalization in keeping with its obligations under the UN CEDAW Convention. So I think that is worth noting. Rwanda further goes on to define gender-based violence within its legislation, and rape is the fact that a person is involved in sexual intercourse without consent by force, intimidators. It has a very interesting wording. It's called conjugal rape, conjugal. I never am butchering it, I'm sure. Is coercing a spouse into sexual relations without that spouse's consent by way of force, intimidation, and others. So under Article 5, conjugal rape Both spouses have equal rights as to sexual intercourse, reproductive health, and family planning. It is forbidden to make sex with one's spouse without one's consent. The penalty for conjugal rape: anybody who coerces his or her spouse into sexual intercourse shall be liable to imprisonment of 6 months to 2 years. I find that very lenient, too lenient. So let's move on. All right, so these are Commonwealth states where the marital immunity stays. And you see Antigua and Barbuda, the Bahamas, you see Barbados, Belize, Jamaica, amongst others. And again, you see St. Kitts and Nevis and St. Lucia, amongst others here, that still have marital immunity. So let's look at the Bahamas now. So this is the current state of our Sexual Offences Act. It's Section 3. And it says that rape is the act of any person not over the age of 14 years having sexual intercourse with another person who is not his spouse. And that's the marital immunity there, or the marital exemption. Without the consent of that other person. B, without consent which has been extorted by threats or fear of bodily harm. C, with consent obtained by personating the spouse of that other person. Or D, with consent obtained by false and fraudulent representations as to the nature and quality of the act. Section 6, any person who commits rape, attempts to commit rape, or assaults any person with intent to commit rape is guilty of an offense and liable to imprisonment for life. But the marital immunity is there, the marital exemption is there. And this is where we stand as of March 15th, is that it? 2022. That's the offense. All right. In the same Sexual Offences Act, it goes on to talk about sexual assault by spouse under Section 15. And it says that any person who has sexual intercourse with his spouse without the consent of the spouse, A, whether there's an existence in relation to them, a decree nisi of divorce, a decree of judicial separation, a separation agreement, or an order of a court for the person not to molest or cohabit with his spouse, or any other order made under Part 2, or where the person has noticed that a petition for judicial separation, divorce, or nullity of marriage has been presented to a court, is guilty of an offense of sexual assault by spouse and liable to imprisonment for a term of 15 years, sorry. So this is the offense of sexual assault by a spouse. And you can see that it's very limited to separation, divorce proceedings. And yes, so we're going to come back to that. All right. So in 2009, those of you who are living, I'm not sure, I'm old enough to know what happened here. A draft of Sexual Offences Amendment Bill was presented before Parliament in 2009, and it sought to amend Section 3. And Section 3, and it says, Section 3 of the Principal Act is amended by the deletion of the words, who is not his spouse. I'm sure you remember seeing it up above. Then it goes on to say, this would be the way the amendment would look with deleting those words. Rape is the act of any person not under 14 years of age having sexual intercourse with another person, A, without the consent of that other person, and B, C, and D, which you saw above in Section 3 in terms of the current status. And this draft bill then sought to repeal Section 15. So in other words, Section 3 would be amended, taking out who is not his spouse. And further after that, that means that it would apply to a man and a woman, spouses, anybody in intimate partner relationships. And you wouldn't need the Section 15 sexual assault by a spouse, because that would be subsumed under this draft bill. So this draft bill was ill-fated. I think it was, if I recall, Loretta Butler Turner at the time would have put it forward, and it didn't get very far. All right, but that was one attempt to amend our Sexual Offences Act to remove marital immunity.
Marion,
Yes.
are there any reasons that you could cite that that 2009 bill didn't move further than it did?
I pretty much the same kind of social response, social political response was evident during that time. The churches, I shouldn't say the churches, many churches and church persons were against it. That was one, there was the volume of that was very high. Yeah, there was a lot of social consternation about it, not just the churches either. But the prevailing social response was not affirmative. It was negative. The political directorate or the leadership didn't have, in my view, the kind of political will to guide it in the way that it ought to have been done for the public. In other words, public, really profound and significant public discussion with an informed positions. I don't recall that being a part of the discussion at the time. So that was my recollection. That was quite a while ago, but yes, it was ill-fated. It didn't get very far in terms of being fully discussed within the parliament. All right, so later on, so that's 2009. So this is 9 years later. There's another draft Sexual Offences Amendment in 2018. And what was put forward then was an offense called aggravated sexual assault by spouse, right? Now, this aggravated sexual assault by spouse is going to amend Section 15. In other words, it's going to leave intact Section 3. It's targeted at Section 15. Okay, so it says the principal act, I don't know if anybody has these drafts in front of them, I certainly do, Lisa, you might. The principal act is amended by the insertion immediately after Section 15. So Section 15, as you saw it above, where you have all the different circumstances of judicial proceedings around divorce, would remain. This would just be a second part of Section 15. Okay, so it says aggravated sexual assault by spouse. A person who has sexual intercourse with their spouse, A, without the consent of that spouse, or B, where the actions of the defendant spouse is of such a kind or in such a manner that if the defendant spouse had used reasonable caution and observation, it would appear to the defendant spouse that there is no consent, or that there would be great risk of there being no consent. He shall be presumed to have intended to have sexual intercourse without the consent of the other spouse, until it is shown that he reasonably believed that the other spouse gave consent. Just going to leave that there for you to perhaps reread. And under those circumstances, the defendant would commit an offense and is liable to a term of imprisonment not exceeding 25 years. So this is what was proposed in 2018. It's not finished yet. That's just Section 1. Let me go on to Section 2 of the same proposal. And it says, for the purposes of Section 1, it shall not be deemed, consent shall not be deemed to exist where the apparent agreement to sexual intercourse is A, extorted by physical assault or threats of fear of physical assault to the spouse or to a third spouse, or to a third person, sorry. B, obtained by the unlawful detention of the spouse, or C, obtained by a pattern of behavior that has the effect of coercing, controlling, exploiting, or limiting the spouse's or dependent's access to financial resources so as to ensure financial dependence. 3, for the purposes of this section, defendant spouse means a spouse charged under this section. So it could be a man or a woman. 4, every complaint under this section shall be made within 1 year after the cause of such complaint shall arise. And 5, no prosecution of a defendant's spouse shall be commenced for an offense under this section without the consent of the Attorney General. So I, for one, have some real difficulties with this formulation of aggravated sexual assault in terms of the temporality of making the complaint for one, and that the Attorney General has to weigh in and consent to the matter moving forward. And further, that it would still leave intact Section 3, which in my mind is still offensive. It would still have who is not his spouse. So therefore the rape definition would stand alone by itself under Section 3, but would not include a woman within a marriage. And then Section 15, the section just before this, aggravated sexual assault, would have the issue of the judicial proceedings during a divorce. So we can talk about all of this in a minute. There is, in 2010, the UN women came up with what was called model legislation. And this can be provided to all of you who would like to see it. And it was talking generally about sexual violence and gender-based violence against women. And it came up with legislation, model legislation for various kinds of offenses under the Sexual Offences Act. Here I'm focusing exclusively on marital rape. And so this model legislation is putting forward that specifically criminalize sexual assault within a relationship, marital rape, either by providing that sexual assault provisions apply irrespective of the nature of the relationship between the perpetrator and complainant, or stating that no marriage or other relationship shall constitute a defense to a charge of sexual assault under the legislation. And when I showed you Guyana, I showed you their formulation of pretty much the same, slightly different language, but grounding it in the fact that there is no marital or spousal immunity. So these are some formulations that can be used. So the UN model legislation is putting this forward as part of a human rights norm that we at the UN CEDAW Committee also share. And so when the Bahamas appeared before CEDAW in 2018, we would have asked, made the recommendation that marital rape be criminalized and that be explicitly criminalized using language similar to this. I just want to go very briefly then through international and regional human rights instruments, which the Bahamas has ratified and therefore is obligated under to uphold and protect the rights of women, married women, non-married women, every woman, LGBTI women, persons with disabilities. All women come under CEDAW, and their rights ought to be protected, respected, and fulfilled under CEDAW. So the Bahamas has ratified these, and I'm really urging all civil society, NGOs, and persons to use these instruments to advance this cause that we are pushing right now as one of social justice and human rights for women. I'll come back to that. So in 1966, there's an international covenant on civil and political rights. The Bahamas ratified this around 2008. And this particular treaty sees marital rape as a violation of Article 6, the right to life, Article 9, the right to liberty and security of person. These human rights treaties generally put out recommendations or what's called soft laws to guide states parties. And so you have a general comment from this particular covenant on civil and political rights on liberty and security of the person in 2014. And it says states parties must respond appropriately to patterns of violence against categories of victims, such as violence against women, including domestic violence. These can be used to pressure the government to do the socially just and human rights-based approach to protecting us all as women. Another one is the International Covenant on Economic, Social, and Cultural Rights of 1966. The Bahamas ratified this in 2008. And again, marital rape under this covenant is seen as a violation of the right to health. It's not that, if you're being raped within your marriage, your health, your physical health, your mental health, your emotional health, all of those are at risk. And so it's a violation of Article 12. Again, general comment, a guidance note to states, a guidance document to states on the right to the highest attainable standard of health. This is what we all as women have a right to. This would then mean that violence within our marriages, violence within our homes is not sustainable. It is not right, and it's a violation. A major goal should be reducing women's health risks, particularly lowering rates of maternal mortality and protecting women from domestic violence. Again, the right to sexual and reproductive health. It is also important to undertake preventive, promotional, and remedial action to shield all individuals from the harmful practices and norms and gender-based violence that deny them their, I'm sorry about that, there's nobody here but me, their full sexual and reproductive health, such as female genital mutilation, child and forced marriage, and domestic and sexual violence, including marital rape, among others. So this particular covenant explicitly names marital rape as a violation of human rights. We have the Declaration on the Elimination of Violence Against Women. This is a declaration that the Bahamas upholds as part of its international obligations. This is a very important UN document. Again, we need to look at it, appreciate it, and use it in our struggle to advance this criminalization of marital rape. So Article 2 says violence against women shall be understood to encompass but not be limited to the following: physical, sexual, and psychological violence occurring in the family, including battering, sexual abuse of female children in the household, dowry-related violence. It highlights marital rape, female genital mutilation, and other traditional practices harmful to women, non-spousal violence, and violence related to exploitation. So it takes various forms of domestic violence and gender-based violence that prevail in different parts of the world. And for us, one of them is marital rape. Again, many of you are familiar with the Belém do Pará. This is the Inter-American, oh, I spelled that wrong, oh, terrible. Inter-American, not Intermercian, Convention on the Prevention, Punishment, and Eradication of Violence Against Women of 1994. The Bahamas ratified this, and this is a convention that is solely about gender-based violence against women. And the Bahamas has to report to the Inter-American Commission on the status of gender-based violence in the Bahamas periodically. So this is another very important mechanism and tool to advance this cause of the criminalization of marital rape. Article 2 says violence against women shall be understood to include physical, sexual, and psychological violence that occurs within the family or domestic unit or within any other interpersonal relationship, whether or not the perpetrator shares or has shared the same residence with the woman, including among others rape, battery, and sexual abuse. All right, and so we come to CEDAW, which is the committee on which I sit, and this particular, excuse me, sorry, this CEDAW has put forward, CEDAW has put forward 2 general recommendations concerning violence against women. Again, I'm really imploring you to look at these. They show that marital rape is a gender-based violence, it's discriminatory, and it violates the right to life, the right not to be subject to torture or to cruel, inhuman, or degrading treatment or punishment, the right to equal protection according to humanitarian norms in time of international or internal armed conflict, the right to liberty and security of person, the right to equal protection under the law, the right to equality in the family, and the right to the highest standard attainable of physical and mental health. And you can see how rape and marital rape would violate all those rights that should be upheld and are the rights of women. Again, CEDAW has specifically said that marital rape is a violation of women's human rights. We have a right to be free from gender-based violence against women, and marital rape would violate the right to equality and non-discrimination. Under Article 2, states parties such as the Bahamas have legislative and policy measures that must be put in place to prevent and protect women from gender-based violence, including marital rape. The right to health, again, is another right under CEDAW, which is violated in the absence of the criminalization of marital rape. So under general recommendation number 35 on gender-based violence, the CEDAW Committee says, ensure that sexual assault, including rape, is characterized as a crime against the right to personal security and physical, sexual, and psychological integrity, and that the definition of sexual crimes, including marital and acquaintance or date rape, is based on the lack of freely given consent and takes into account coercive circumstances. Any time limitations where they exist should prioritize the interests. Let me just close my. I'm sorry. Any time limitations, and you saw that the aggravated sexual assault by a spouse had a time limitation of a year, I think it was. Any time limitations where they exist should prioritize the interests of the victim survivors and give consideration to circumstances hindering their capacity to report the violence suffered to the competent services or authorities. I'm almost finished here. So here are some recommendations for the way forward. I would stand by the following. Amending the Sexual Offences Act, Chapter 99, Section 3, by eliminating the words, who is not his spouse. Further, I would want to see that this, a further amendment that includes a statutory definition of what may or may not constitute consent. As it stands now, the Section 3 refers to the penal code as the reference for understanding consent, but I find that that particular penal code's definition of consent and the guidance around it is not adequate in regard to sexual offenses. It can be used in other kinds of offenses that are not sexual offenses. And so my proposal would be that we look at a statutory definition of what may or may not constitute consent. This is also a proposal by the commission that looked at gender-based violence and came up with a strategic report on gender-based violence. So that would have been Dr. Sandra Dean Patterson, Dr. Robin Roberts, and Justice Ruby Nottage. And they also support this inclusion of a statutory definition of consent. Further, I think we can amend Section 3 or the Act itself, Sexual Offences Act, by including this issue of no marriage or other relationship shall constitute a defense to the charge under the legislation, or a marital or other relationship is not a defense to a charge of any other offense under this Act. Whichever formulation, there are several formulations that are possible, but I think that needs to be explicitly placed within the legislation, the amendments. And then we could repeal Section 15 because it's no longer viable or needed, because anybody, whether you're going through divorce proceedings or not, would be protected under the amendments of Section 3. So you wouldn't need Section 15 at all. And then I really have to say that I really would want to give a strong shout out for NGOs and advocates around this to use the relevant conventions ratified by the Bahamas, all right, to advance this issue of intimate partner sexual violence and rape within a marriage. It's really important. And I just want to say that, you know, this is exactly what women in the 40s and 50s and 60s did when they were fighting for the right to vote and the right to stand for election. They used the UN instruments to advance their cause. And so I think that would strengthen the domestic initiative and also the international initiative. So in closing then, I just want to say two things, and a little bit of repetition, and then we can go back, is that a country's criminal law power is an essential mechanism, resource, by which a country can tell us, signal to us, and shift norms within the country. So the cultural norm that we have now is that it's okay to have rape within a marriage. That is where we are, all right? And I am saying that we are asking the state to use its criminal power to shift that national norm, to transform it, okay? Such that sexual violence in intimate partner relationships and between spouses is no longer seen as acceptable. This is what the state party needs to do in terms of its leadership and its power, use the criminal law in this way. And so it's really critical to change what we call the normative level, the norms in this country. And given the long entrenched ideological and historical origins, colonial origins of this sexual spousal immunity, we really need to ground this criminalization of marital rape. It's been almost 300 years of existence. And so we need that kind of state power to make a difference and to transform where we are, given how entrenched it is in our culture and our psyche and our social life. Secondly, I want to say that human rights groups around the world and here in the Bahamas can rely on these international covenants, as I've said before, these international conventions, to demand the criminalization of marital rape, because the state party has an obligation under these international conventions to do that. And so the demand to end marital rape is not just it's more than a demand for a penal remedy. It's a demand for equal rights. It's a demand for social justice. It's a demand for equal protection of women under the law and internationally. This is what it's about. Okay, I heard one minister say something about, if you want to get a conviction under marital rape, you have to change the word marital rape or something to that effect, right? We're not focused at this moment on the penal remedy. We're focused on gender equality, equal rights under the law for women, non-discriminatory norms and standards that protect women. This is what we call substantive equality. And so using these human rights instruments takes us in that direction of substantive equality, to ground the personal bodily integrity and sexual autonomy of women, all women. This is our right to our bodily integrity, and to use our bodies in the way that we want to use them, and not as an entitlement to men. And so the existence of a criminal remedy in marriage is a crucial form of the state signaling to its citizens that it condemns rape within a marriage, and that it is about the obligation of protecting the equal rights of women and the non-discrimination of women on the basis of sex. Prevent this violence within intimate partners. And so I'm really asking that we combine the international human rights treaties along with our push for social justice at the domestic level, which is powerful. It's a moral imperative that rape within a marriage be criminalized. So I'll stop there. Thank you. Thank you, Alicia.
Thank you so much, Marion. This has been really helpful. You really gave us a lot of great context for understanding this issue and why our law is framed the way that it is, and the importance of reforming, changing the law to definitely criminalize marital rape and to do it in a specific way. Can you tell us, why do you think the bill or the framing of this amendment changed between 2009 and 2018?
Well, it is my view. And in 2018, as I said, the Bahamas went before CEDAW. I think it may have been November. Alicia, I think you were there, November 2018. Yes.
Yes.
And the Bahamas, October. The Bahamas also appeared before the Human Rights Council with an update on the Universal Periodic Report. This is my view is that this is really an answer to the pressure, the international pressure, and the obligations that the state party is under to deliver on. And so to appear before these bodies is no small thing, you know, and my understanding is this was in part done in preparation for that. Now, I have some difficulty with that in the sense that I am still very much, I mean, I think this cause can be advanced just from a domestic level. You know, it ought not take international pressure to do this, but I'm saying we can use it, but this demand must come from within our country. I mean, we as people need to have to want this, you know. I'm only referring to these international conventions because they are also useful, very useful. So back to your question then, in 2018, we appeared before these two human rights bodies and had to show some kind of forward movement from, I think it was 2012 when we were there last, you know. And so it serves to show that there is some sort of impetus behind the use of these conventions. I mean, I sit on the committee, so I'm already, you know, you're preaching to the choir in a certain kind of sense. But my emphasis is really about our domestic demand for this. So I hope I've responded to your question in one way, because that was my understanding.
And the framing of it, because in 2009, it was closer to what you're recommending. And in 2018, it moved backward.
Yeah. So yeah. So I'm sure you remember the debates around 2016, 2017. I mean, again, it was a lot of resistance and concern about criminalizing rape within a marriage and what it means for the family and for spouses, etc. So I think everybody probably on this call would have remembered the clarion calls not to do this. And so I think the aggravated sexual assault by a spouse is a compromise position, so to speak, you know, because even when this was put forward to CEDAW and the HRC, the Human Rights Council, you know, the special rapporteur, for example, you know, said clearly that it has to be criminalized, which this does not do in essence, and that we have to not allow any marital immunity. So, and she also said that the temporal limitation was very problematic.
Yeah, and I see we have a comment in the chat saying that it's interesting that Minister Wayne Munro is seemingly siding with diluting marital rape to spousal sexual assault, and the word in the marketplace are once again causing confusion and diversion. Today's chatter was based on the, quote, fact that a bill to legalize marital rape and same-sex marriage will soon pass through the House. I wonder if the legislative bodies are actually supporting this discourse, hoping that the mood of the public will turn against any changes in the sexual offenses bill. We have another comment. Thank you for this presentation. The current Minister of National Security claims such amendments will not result in convictions. Is there any merit to such claims? And would there be a need to push education in parallel with such amendment?
I'll start with the last words that you're saying. Criminal law alone is not going to transform what needs to be significantly transformed. And that is our consciousness, our mindset, our social norms. So criminal law is one aspect of a huge social project, that national project, let's put it that way, of education, raising awareness, from primary school through to secondary school, through to university, all sectors of our community, the church, the places of employment, the public service, everywhere. We need public education programs, the judiciary system, the legislature. Every aspect of our society needs that kind of awareness, raising an understanding of the elements of gender-based violence. And this is, part of a patriarchal system which sees women as subordinate fundamentally to men, and promotes, when we socialize our young boys and girls in this way. So yes, in terms of what the last person was saying, criminal law alone, criminalization alone will not cut the mustard. It won't make the kind of change. And as for convictions, I think even now when we look at rape, we don't get the kind of reporting and the complaints making that is needed. In my view, I think rape by itself is underreported. And so when you're talking with marital rape, that is an even more, even if this were criminalized, the question is, will women come forward and report it? I can't say that. I don't know the answer to that, but the point I was making is that, we're talking not just about the penal remedy, we're talking about our country condemning an action that is wrong and signaling to us that we need to change and transform our cultural norms to respect the bodily integrity of a woman. And so how things unfold after that is a part of the education that we will all need concomitant with criminalization to make the changes and transformations in this community. I hope that responds to some extent.
What else do we need aside from reforming amending the Sexual Offences Act and education? What else do we need? Because we know that passing laws doesn't directly impact our lives. There's usually a need for certain things to happen for implementation. So are there any things that you have in mind that need to happen alongside this legal reform?
Yeah, I really think that, and I'm talking generally now about sexual violence, gender-based violence in general. I do think that the strategic plan has some very valuable recommendations that we ought to pay attention to and implement. For example, the gender-based violence authority, which is the authority that would bring together a multi-sectoral approach to gender-based violence. So you'd have a council that would consist of several ministries: Ministry of Health, Ministry of National Security, Ministry of Social Services, all the ministries that are relevant to this issue of gender-based violence. And so the authority would have that at its fingertips, so to speak. It would need the kinds of resources and the personnel that really understand issues around gender-based violence and the root causes of gender-based violence. So yes, I would be a supporter of instituting and establishing this gender-based violence authority that could coordinate approaches to gender-based violence. So it would coordinate, for example, shelters, licensing shelters for women, psychosocial responses for victims and survivors. It would also establish programs to prevent gender-based violence, which would include programs of awareness raising and public education and understanding. So along with this criminalization and amendments, yes, I would support this authority that is part of the strategic plan to address gender-based violence, and have that as the central focal point that could then address issues such as statistics, for example, because one of the things that we really need is we need to know what, how many femicides there are, how many, what is the documentation around sexual violence, so that we know what kinds of gender-based violences are taking place. We need to know numbers, because this can then inform policies and programs moving forward and further amendments. So the centralization of this kind of work, I think, would be very, very helpful.
Yeah, we definitely need that gender-based violence authority. It would fill in a lot of gaps that we have right now. I see we had a hand up from Boykin. Boykin, do you want to come in with your question or comment now?
Yes, thank you. Good evening, everyone. Good evening, Dr. Bethel. This was a excellent presentation, very informative.
Thank you for giving me the time. Thank you for giving me the honorary title of doctor. I'm not a doctor. I don't have that as yet, but you're welcome to bestow it upon me.
Apologies.
That's all right.
Miss Bethel. Well,
I love it.
I think this conversation is, very important. We have, Lisa was having this conversation before with Org and other folks, and I do agree that it is interesting that the approach that the movement would want to go about bringing the change is from the state. The state legislating to change the social behavior. But from my experience on the ground, there is the education aspect of this issue that we have already addressed that needs to be changed. And we have a real serious a lack of cultural understanding of the issue. And I think I want to draw my question to even your recommendations about the definition of consent. Because, for example, I can give a little anecdote of a conversation that I had with a woman who experienced marital rape, but for her, she said that she allowed it to happen. That's it. Well, she allowed it to happen because, they just wanted it. And so when I heard that, to me, that isn't the definition of consent, but to her, as a woman in the marriage, she believes that was normal and expected. So I'm just interested of your insight of what consent would look like. Is it looking something like the congenial rape article example? Is it as complicated and complex as the abrogating sexual offense that was put forward in 2018? Or is it a little bit more clear cut to help us navigate through to change that culture and to inform folks about it? I did notice, I did note that you mentioned that it's not all about the penalty. We're looking at, creating laws that will change the culture and make for a safer space for women. But I also do think about that when we look at each offense. So in the current shape up, the recommendation is to remove who is not his spouse, which will mean, those ones in the other offense who have a separation agreement, obviously will get the higher penalty of life in imprisonment, which is obviously fair. But in certain circumstances, in particular to the marriage, is life imprisonment a valid, penalty for the offense? I'm not explaining that quite well, but I'm wondering if there's conversations about that the change of that, and looking at the different years that the different jurisdictions have. I saw 15 and 25. And I do have a few, another point of whether there was any considerations of or provisions in considering children and protecting children and youth, despite the social agreements that couples may have. So I gave that anecdote of an example of where this marriage believes that this is the norm. And what if there's a marriage that actually has an agreement in the marriage, the vows, that this is what would be expected? And so how is that the recommendation taking away from that agreement, even though it's completely against the fundamental rights of a woman, as we would see objectively? So these are just complex issues, and I'm sure you can speak in great depth to it. And I'm enjoying what I'm learning so much from you ladies.
Yeah. All right, you've said quite a lot, and I was taking a couple of notes. I'm not sure I remember everything. But what the law is poised to do is to uphold the rights for all women. All right. So once the law is in place, it would protect women from this rape within a marriage. Now, what I'm hearing you say is that there may be a woman who wants to have sex have sex as a duty, as part of her spousal duty. That does not take away from the implementation of the law. In other words, the law is there, and so if a couple has that understanding and wants to live life in that way, this would protect other women who don't want to live life in that way. You see what I'm saying? So it's I mean that's one way of looking at it. But the law is there to protect all of us, and there may be personal kinds of positions within the marriage. I can't do anything about that. But what I would know is that there would be a law in place that is there to protect women from rape within a marriage. That's one position. I don't know if anybody else wants to comment on that. But that was just one part of what you said, and perhaps Lisa, you can direct me to another part.
Yes, I agree with that.
It was quite a lot.
Yes, I agree with that. That's very true. How it's being implemented and how it's reported, and there's so many challenges with that, for sure. I think the question was about children.
Okay, I'm not sure I understood the question about children, but let's come back to the children one. And you were talking about consent too, as I remember. I do think the issue of consent needs a lot. I do think the issue of consent needs a lot of attention. And that is why I was proposing that there be some statutory definition. There is legislation in place that we can look at. For example, the one in Guyana that I find quite compelling, that gives various circumstances. So it can be, I should say, a thorny area, or an area that seems muddled and not clear. And so that is precisely why I do think that we should have statutory guidance as to this issue of consent. And I would want to refer you, perhaps Alicia, you might put that into the chat, so people can look at how Guyana, for example, addresses the issue of consent and gives it's very nuanced and very, very helpful, I found. So yes, I would agree with you that is something that we don't sort of cavalierly ignore, but that we do look at this issue of consent. And sorry, and then one with the children, I'm not sure I understood that in the context of this marital rape criminalization that we're focused on.
Boykin, can you put that question in the chat, just so I can follow up with Marion on the consent conversation, and then I'll bring it back up. I'll read it in the chat.
Yes, I think it hangs on the conversations that we were having of the other questions, really, about the social relationships and expectations. So if there's a child, that's existing in a social space where the marriage thinks that marital rape is acceptable, and they aren't really protected, and they're involved in that violence. Yes, I agree absolutely with Ms. Bethel that, you know, the implementation and creating the laws for the avenues to get it, to allow for the protection of women is very important. And the education around it and the actual provisions of, you know, consent and educating folks of what that means will make the difference. And I would hope for our leaders to have those conversations and focus more on that as well, and take heed from these conversations for sure. But I don't think it's possible to answer that question for the children, right? Because it's all about the implementation.
It's not really clear what you're asking about children, but could you kind of form it into a succinct question and put it in the chat for us to revisit, so that we have a chance to take some other questions and comments? If you could just formulate that in like a 8 to 10 word question so that we could understand what you're trying to get in the response. But Marion, I wanted to revisit this question of consent and what are the elements that we would be looking for in this definition, and what does it mean to have a statutory definition of consent?
Well, it means that, statutory definition means that it's part of the legislation. It's a part of the legislation. And Elisa, I'm almost going to ask if we could show what Guyana has done, so that we can actually visually see it. I think so. So should yes. I not stop sharing mine?
I can share my screen to show the Guyana legislation. Sure.
Because there's a view, and I'm, given all of the discussion around consent, I think it starts at section 4. Arguably, and this is arguably, and this is all part of the discussion that we as a community can have, arguably the only way or the main way that a woman's right to personal security, bodily integrity, and sexual autonomy are manifestly protected can be through an affirmative consent. In other words, yes, I want to have sex, or by some other language that's peculiar to you and your spouse, it's an affirmative consent to have sex. That, we may need to think about that. Given all of given where we are right now and the confusion that I hear that some people are experiencing around it. But let's look at, it's further down. Okay, so section 7 and 8 relating to a person. Okay, so sorry, go back up, Alicia, I'm sorry. Okay, right, consent, I think may start at 4. That's 5. It may start at 4, I'm not sure. Okay. Number 2, section 7 and 8 relating to apply to an offense under this section. Okay, so let's go down to 5. Okay. Consent and belief in consent cannot be inferred by A, reason of silence or lack of physical resistance on the part of the complainant, or B, reason of sexual arousal, including orgasm and ejaculation. 6, where a defense of belief in consent is raised to the offense of rape or sexual assault, the belief must be objectively reasonable. 2, whether belief is reasonable is to be determined having regard to all the circumstances, including any steps the accused has taken to ascertain whether the complainant or the third person consents. It is not a defense to a charge of rape that the accused reasonably believed that the complainant consented to the sexual activity that forms the subject matter of the charge, where the belief of the accused arose from the self-induced intoxication or reckless or willful blindness of the accused, or the accused did not take reasonable steps in the circumstances known to the accused at the time to ascertain that the complainant was consenting. If in any proceedings for an offense under section 3 or 4, it is proved that the accused did the sexual activity, any of the circumstances specified in subsection 2 existed, and the accused knew that these circumstances existed, the complainant is to be taken not to have consented to sexual activity unless prima facie. I'll just read to the end of this. Evidence is adduced to raise an issue as to whether the complainant consented, and the accused is to be taken not to have reasonably believed that the complainant consented unless prima facie evidence is adduced to raise an issue as to whether the accused reasonably believed it. Now, it's hard to absorb all of this just at first reading, but the point I want, so this is a statutory definitions of consent and circumstances around consent. And I think that this kind of statutory references are very helpful to navigating this issue of consent. So Guyana is one benchmark. We can look at other countries. Canada has a very, very, very much more detailed statutory definitions of consent, very detailed. I mean, it's quite nuanced. So the point I'm trying to make, I'm wanting us to be aware of is the possibilities that exist compared to where we are now in our draft legislation. I think that's my intent at this point. And so much more work has to be done. I'm not satisfied with where we are in terms of our draft legislation. And so Boykin, I hope that has helped to some extent, that I'm a strong advocate of more paying attention to consent, circumstances of consent, and that it be made part of the legislation.
Thank you for that. I think it's good to see what other countries have done and see the level that some of the laws are at, and it helps us to understand how far behind we are and some of the possibilities that we can consider. It's really important to have these comparisons. I see we have another question. I'm sorry that I missed this earlier. Glad I see it now. What is the legislative process to amend the Sexual Offences Act, Chapter 99?
That's a good one. Now, I used to work in the Attorney General's office a long time ago. I'm not sure, but I think generally speaking, the country can weigh in. Okay, NGOs, stakeholders have been, you know, can give responses to the draft that you see before you. For example, the aggravated sexual assault by spouse. Every citizen is entitled to weigh in on these drafts. The drafts are done within the Attorney General's office, and once they reach a certain point, they're then given to a particular minister, perhaps the Attorney General, who will lay them before Parliament. So, but before it's laid before Parliament is where we need to have our input, you know, as to the amendments and the critiques and changes that we want to make. So it's at this point right now that NGOs and women and groups ought to be making representation to help guide the next draft. I hope that will come out. I trust that the current one, aggravated sexual assault by spouse, will not be the one that's, I shouldn't say I trust, I hope that is not the one that will be laid before Parliament. All right, and so if we are not happy with that, then we right now, in this very moment, tonight, tomorrow, we have to speak up and make our voices heard through our representatives. We can do it through the newspaper, we can do it through our churches, our NGOs.
Yeah, and for those who are joining us and who may not have considered this before, because I think most people haven't even seen the draft, right? Because it hasn't really been shared very publicly. Can we go through some of the items in that draft that are, and explain why these are issues, why we cannot allow this to pass the way that it is right now? So for one, it does not look at the definition of rape. It does not change the definition. It attempts to create this other category, right? So what is that proposed amendment doing to Section 15? What is the effect of what's proposed there?
it's extending the current section 15. So section 15, as you know it, would remain. I'll just go back to it. The one where you have the judicial, yeah. Well, this is section 15.1. All right.
And section 15 is like a sort of special category for people who are married but no longer live together, essentially.
Yes, who are in the process of a divorce or judicial separation, or have a separation agreement, or have a protection order under small 4 out. Yes, an order from the court for the person not to molest or cohabit with this person. So this would remain. What is intended here is that
we're not seeing. Do you want to share your screen again?
Oh, you're not seeing it? Oh, sorry. I'm looking at it and I'm not when I'm talking. 1 minute. It's gonna. Let me see. Okay, is it up? Is it up?
Not yet.
Yes.
Not yet. Oh, it's
Okay,
coming.
so
It's coming.
Tell me if it's up.
Yes, we've got it.
Can you see it?
Mhm.
Okay. So this is where we are right now. Aggravated sexual assault by spouse. So what would happen is that section 3, as it stands now, would remain. I'm just going to go back to section 3. Okay. This here would remain on the books. All right. Can I move on? Can I move to the next?
Yeah, so just in case people aren't able to see it, this is
So
showing the definition of rape. And it says, rape is the act of any person not under 14 years of age having sexual intercourse with another person who is not his spouse. And then it goes into a couple of sub sentences. So that would stay the same.
That would, because if you look at this very carefully, it says the principal act is amended by the insertion immediately after section 15 of the following new section. It doesn't say anything about section 3. So section 3 will not be tampered with this new aggravated sexual assault by spouse. Only section 15. Okay. And as I showed you before, section 15 shows the different degrees of divorce proceedings where rape within a marriage can take place. And so this is a sexual offense act, sexual assault by spouse under those circumstances. The new amendment would extend this section 15, all right? That's exactly what it says. The principal act is amended by the insertion immediately following after section 15 of the following new section. Aggravated sexual assault by spouse. A person who has sexual intercourse with their spouse without the consent of that spouse. I think everybody can read it, right?
Yes, I think so. So it's not calling it rape, it's calling it something else, aggravated.
Yes, it's calling it aggravated sexual assault by spouse.
And can you share why you and we at Equality Bahamas oppose this approach?
Okay, so Alicia, you start with that. Okay, I think I'd like the audience to hear from another person. I've pretty much said that rape within marriage is rape. I read the House of Lords dictum, and that's not what influences me. I know that rape within a marriage is rape, and so it needs to be called that. And so we get back to section 3, which is where there's a definition of rape, and rape is constituted as a sexual offense. This is a compromise position that does not call a spade, or the action or the offense what it truly is. So anybody else can weigh in there. Alicia?
Yeah, and I think Yeah, of course, rape is rape, and it's something that we continue to repeat. It doesn't matter what you put in front of rape. You can call it marital rape, you can call it whatever. It's still rape. And like you said, this is a compromise and it's an unacceptable one. And we also understand that law helps to create / maintain / shift culture and the way that people think about things. And if we refuse to acknowledge that rape is rape and we leave Section 3 as it is without exception, who is not his spouse, and create this new category, it's like we're validating the idea that people, women in particular, are less than human beings, and particularly when women marry, we sort of give up this right, and we must submit to the whims and wishes and desires of the spouse. And to continue, we continue along these lines of saying that women are less than, and even worse, married women are less than. And it means that we do not all have equal protection under the law. So unmarried people have more protection under the law than married people. So there are serious fundamental issues with this from our perspective at Equality Bahamas as well.
An unmarried woman has more right under the law than a married woman. It's not people, it's unmarried woman and married woman. You're right. And I mean, I can't help but put in here that, you know, this will be my perpetual cry, is that our Constitution endorses this. Our Constitution anchors this subordination of women and the inferiority of women. We are second-class citizens under our own damned Constitution. For goodness sakes, I mean, can we? It's difficult to unanchor ourselves from that principal legal architecture that is the pinnacle of our country, that endorses discrimination against women and giving us a second-class citizenship. It follows that this is where we are, and this is why we have to change it. So I will forever be saying that and feeling very disturbed and frustrated. It flows from the top, right through to all of this.
It's consistent. It's consistently misogynistic and unequal.
Absolutely consistent.
We have a question in the chat. Why wouldn't the AG's office have included the consent aspect? And what should the role of the Gender Affairs Department have been in this process?
Very, very good questions. Well, the AG's office is the drafting department there acts on instructions. You know, it doesn't necessarily create the concepts or the content. It acts on instructions to do certain things, and it's drafted in certain ways. Yes, they can look at it. They do have the capacity and the personnel to look at other benchmarks, and that is often done. But at the end of the day, it's the political directorate, the legal, political leadership that fashions and makes the determination. However, it is the people, we the people, that need to prevail upon our political leadership to do the morally just thing. So that's one response. Drafters generally act on instructions. Okay, the Department of Gender and Family Affairs, in my view, has a huge role to play in guiding this process and lending leadership and understanding of the terms and the root causes of gender-based violence, inclusive of marital rape. It has a huge responsibility, and it needs the kind of resources to deliver on that responsibility. I've had engagement with the Department of Gender and Family Affairs for over 30 years, and I've seen it grow from 1986, when it was called the Women's Desk, to what it is now, the Department of Gender and Family Affairs, with a little more autonomy, but independence, I should say. But it needs much more. It needs a huge infusion, not just of money, resources, but of the kind of training to really deliver on this mandate of gender equality and non-discrimination against women.
One of the other issues in the current draft that a few of us have talked about, not everyone who's having conversations about this is raising this, but the temporal limit, that 1 year for
Yes.
reporting.
Yes. So, right. So yes. Can I come to that 1 minute, please? I just want to go back to the Department of Gender and Family Affairs,
Sure.
which is the national women's machinery. It really is the body that needs to be fashioning a gender policy and a policy on gender-based violence, etc. So it needs the kind of tools to do that. And in my view, the work that comes out of the Department of Gender and Family Affairs needs to be guided by a policy, a document that lays out a strategic calendar and plans and programs that are based on a policy. And that policy has to be informed by, I've said it before, documentary sort of evidence of the kinds of gender-based violence that takes place, the frequency. We need statistics. We need a whole lot in order to really formulate a strong policy upon which we can rely moving forward into the next 10, 15 years. And so the Department of Gender and Family Affairs has a huge role to play in putting forward the kinds of programs and public awareness and public education, but it must be policy-based. It can't just be episodic programs here, there, willy-nilly, that aren't coherent around a policy, a national policy that has benchmarks and timelines and objectives and is accountable, you can measure progress. So that's just what I wanted to add about the Department of Gender and Family Affairs. In terms of the temporal, the time limitation, Section 3, the rape offense doesn't have a time limit. Why would we want to have a time limit, period? Okay, in a sexual offense. We know circumstances under which women experience trauma from sexual violence, and responses are so varied and different, and placing any time limit on when I might be ready to make a complaint to the police, for example, is discriminatory, to put it bluntly. And in point of fact, there is no time limit under Section 3. So what is the point of this except to frustrate? And as I say, we know sexual violence cases are very complicated. The trauma and the degree of harm that is caused, it's very difficult often to live within anybody's timeline. It's a very, very individual process. Anybody else want to weigh in on that? So I would not support this timeline.
For the record, we don't support it either at Equality Bahamas. we are very much in line with the recommendations that you've made, Marion, and just addressing the definition of rape, addressing Section 3 and repealing Section 15 and being done with it. I see that, Fran, you want to jump in here? Please unmute.
Yep, I don't know if you can see me, but okay, I am.
I can see you.
I just wanted to go back to gender affairs. Hi there. My concern, I guess, why I was asking about the. I feel with the UN treaties that we have signed on to, the gender affairs department, I feel like they have through the United Nations. And so I'm just saying that, like you said, with the Bureau, we're not moving forward. And they should have a big role to play in this and that. So when we see a first draft, somebody has dropped the ball in a major way if these things are not included in the draft. So the AG's office could say that they were instructed by someone else, but I'm saying the gender affairs needs to be there stepping in saying, listen, you left this out and left this out because we said that this is stuff that we're going to put in. And I just, how do we make this happen? I just feel like we're paying people to do this and it's not happening. It's so frustrating. And I guess I wanted to say that so that other people could, think about it. Maybe we could all push together. But like I said, I feel like we're doing what we want to do to put the things in place, but nothing is working the way it's supposed to.
Yeah, agreed. I think we have to, I think we have to get in there in the Department of Gender and Family Affairs. I know, NGOs are members of the Department of Gender and Family Affairs, and their meetings I don't know how regular they are now, but we have to weigh in on how the department is structured, how it does its work, and whether it has the kind of resources to do its work in terms of human personnel who are trained to do this work, in terms of the technical resources, financial resources. The budget is very limited, and we are the taxpayers. Let me just make that very clear. So these are other things. I mean, there's just so much work to be done, and Fran is quite right. But we, the citizens, have the right to make these demands, to have the department do live up to its mandate and do its work. And we also need to get more resources for this department too, as the taxpayers that we are. It's a lot of work we have to do.
Thank you for that. I see we also have a hand up from Kay.
I'm unmuting myself, yes. I think one of the challenges of legislation trying to work from within the state is that we have a culture of male privilege and power that is resistant to women having sexual autonomy over their bodies. And that is the fundamental problem. Now, I agree that, yes, it would be good to have Office of Gender Affairs that was efficient, that was policy-based. That would be good. But I think that the crucial and main problem is not inefficiency or lack of knowledge. It is this culture that has to be resisted. And I think resistance will mainly come from the outside, not the inside. Although I think you need to do both. The expectation that simply you put policies, recommendations forward, and somehow that's going to translate into legislation and law that affirms women's autonomy, that recognizes rape for what it is, fails to recognize an entrenched male privilege and culture that's predicated on affirming the appropriation of women's bodies, the right to control women's bodies. And that is what is being represented in this draft. So unless there is organized pressure from the outside, very significant pressure, there is unlikely that the change will be easy. And that's why it's taken this long. We've been talking about rape and marriage for decades. And we're still talking about it for the very reason And so unless those who believe in women's self-determination are willing to organize, and even in a radical way, to really show that this is intolerable, we will continue to have this challenge, this resistance to substantive change as we have around the constitutional amendments that recognizes equality. All of this is connected.
Yeah, Kate, I agree with everything that you've said. I'd just like to go back to what I was conceiving in regard to a gender policy. A gender policy would incorporate exactly those things that you've said. In other words, a gender policy, a national gender policy, which is human rights-based approach, would incorporate the issues around male entitlement and male privilege, the lack of self-determination of women over our bodies. That would be all of patriarchy. That would be part of the gender policy, which would then have to respond to addressing all of that. So I do believe that there is room for a gender-based policy that really understands a human rights-based approach to gender equality and non-discrimination in regard to women. And that policy would incorporate all that you've said and therefore reflect in the programs and the way forward as to how to address those very things. Now, that you also need the pressure from the outside. I agree with you on that. So it's a multi-sectoral movement. It's not just the department that has this obligation. I would agree with you completely on that. I was just responding to what the department must be doing and should be doing. And it will still take NGOs on the outside to levy the kind of high pressure that is needed to keep us on target. I thank you for what you said. It's right.
Well, I agree with you, because there are instances even in our and when it hits, when it goes to the state and legislators have to vote on it, what happens? It dies. So absolutely, it's necessary, but it's not sufficient. Agree.
Okay, it's almost 7:45, Alicia Wallace. I know you want to go forever.
Do we have any last questions? This is your last 5 seconds to indicate that you have questions, but know that this is not the end of our conversations and the work that we need to do to move us forward. As I mentioned at the top, this is a part of a series, building the gender machinery, recognizing that we don't have that. We don't have what we need. We don't have this central coordinating unit that is working toward the advancement of women, gender equality, and specifically eliminating gender-based violence. So what do? Throw our hands up? No, we look at the tools that we have available to us and we use our own power as the people to push for the changes that we need to see and educate ourselves, encourage each other to step up, because we are not going to be able to get the amendments that we want unless we raise our voices and make some noise about it. And it looks like legislators are prepared to either just let this die in conversation or move it through the way that it is, and the way that it is right now, as we've discussed. And as you have hopefully seen from Marion's presentation, is far from good enough. And in some ways, it's actually harmful. So please stay engaged in the conversation. We have some other events in this series. On Saturday, we have a session with Gaynell Curry that starts at 10 a.m. looking at the draft national gender policy. So what does that draft look like? What's in it? What is the purpose? Is it doing the thing that it's supposed to do? Where are the gaps? And what kinds of recommendations do we need to make to strengthen that document? If it can be strengthened, or maybe we need to start from scratch, we'll see. But we'll walk through that document and take some notes together and see where we need to go. So that's on Saturday, March 19th at 10 a.m. And then next week, Saturday, March 26th, we have a session on gender inequality in nationality law. We haven't talked much about that recently, but it's another thing that we can't just let die. It's something that really needs to be addressed at the constitutional level. So we will be in conversation with our friend Bina from Family Frontiers in Malaysia, where they have had a series of successes in challenging their laws. And now they are at the point where women are able to pass on their citizenship. That's kind of the final answer. So we'll hear from them about their advocacy, what has worked for them where they are now, because their fight continues. We'll also have Amal de Chikira joining us from the Institute on Statelessness and Inclusion, and Catherine Harrington, who is the chair of the Global Campaign for Gender Equal Nationality Rights. So that should be an interesting event, Saturday, March 26th at 10 a.m. So the link to register for the gender policy walkthrough with Gaynell is tiny.cc/IWD policy. And the link for the other event on nationality rights is tiny.cc/IWD nationality. Of course, follow us on social media everywhere. We're Equality242 to keep up with the events that are coming up and the actions that we're taking. And coming up very shortly will be the relaunch of our Strike 5 campaign, which is all about striking those last 5 words from that clause in Section 3 of the definition of rape. So striking out who is not his spouse, recognizing that as the best way and really the only way to criminalize marital rape. So stay tuned for that. We'll be releasing some graphics that are great for social media. We need you to flood your social media pages with them and show that we do have the numbers, we have the strength, and we are not going to stop until we get exactly what we need. I think that is pretty much it. Big thanks to you, Marion, as always, for joining us. You always answer the call. We're a little tiny baby organization, but you're like one of our top resources. So thank you for joining us and doing this and walking us through this. I'm sure this is a recording that people will be able to revisit over and over again to kind of really see the issues with the law and the proposed amendments and why we are pushing for a different way of going about this. Thank you to everyone who's joined. Thank you to the Equality Bahamas team that's always making sure things happen. In particular, today we have Lauren who's co-hosting and helping to manage tech stuff and chat stuff. We're looking forward to seeing you at the next set of events. So Saturday, this Saturday, and then next Saturday. And then we'll have some other events looking at the strategic plan to address gender-based violence. We'll be looking at the gender-based violence bill that there's a lot of conversation about. And believe me when I tell you, there are people out there who are just pushing for these things to pass. We don't know that they're good enough. So do not join the choir just because it sounds good. Have a look at these documents yourself. Join us. Let's walk through it together. Let's have some conversations. Don't go out there just supporting things you don't know anything about yet. Take it easy. We're going to go through a couple of these sessions this month as well as in April. That is it. Have a good evening, everyone. See you virtually soon.